Hi everyone. Welcome to the very first class of our paper 13 Corporate and Economic Laws. We are discussing the syllabus 2022, right? Now, what is there in the syllabus? That's the very first question. After that, we'll know about our subject and then, of course, we will start our study. So, today's class is going to be an introduction, not deep into the core content, just the basics, which many of you might already be knowing. Okay, so, how our paper is designed, what is there in our syllabus? The syllabus might look very tiny to you because it is being covered in one page, but trust me, it's huge. Okay, so you have a lot of things covered in your syllabus. You have to read a lot of content. When I say it's Companies Act, there is a lot of content. So, our paper, as the name suggests, is divided into two parts: corporate laws and economic laws. Under corporate laws, we have three things that we have to study: an act, a code, and a topic. So, Companies Act 2013, which has the highest coverage of your syllabus, and I think it's going to take almost half of your time of the whole content that you read, because Companies Act has a lot of content. Even in terms of the coverage, I don't think that's very much justified, but still you have a lot of content. Okay, so Companies Act 2013, which has 40% weightage, IBC 10%. I would say excellent topic with respect to the current scenario, and decent coverage that has been allotted. Corporate governance, which is not very much interesting as compared to the other topics, but yes, you have a decent coverage for the same 10% again. Then we have economic laws, in which you have to read SEBI regulations, which includes the act as well. Competition Act, FEMA, that is Foreign Exchange Management Act, some laws relating to the banking sector, some laws relating to the insurance sector, some laws or specific provisions to the MSME sector, cyber security, data privacy, a new thing, and MSE also is a new thing which has been introduced, and also some laws and regulations relating to anti-money laundering. So all these have 5% coverage. So section A is basically 60%, section B is 40%. Of course, the questions asked in examination will be a mix of subjective and objective. So keeping that in mind, we have to prepare ourselves. Okay, so we must have an idea, an in-depth idea, I would say, about the whole content. Also, we should be on our toes, on our tips when it comes to learning the crux provisions, right? So, if I talk about a subject like law, corporate and economic laws, where even the syllabus is huge, you have a lot of content to cover. The major problem that the students face is they are unable to retain the provisions. And for retaining, no matter how many times I give you the tip, the students hardly follow it. But today, we have to discuss certain very important things. What are those very important things that are needed now? See, we are talking about a subject like law, in which ideally there are four aspects. What are the four aspects? Understanding law, learning it, revising it, and then presentation. Okay. Since you're on this journey with me, you're starting a tough subject of law like law with me. You have to develop some very good habits right from the beginning. I always say this to my students, that you are the CEO of your own life. So hire, fire, and promote your habits accordingly. So develop some very good habits of learning law straight and right from today. When I'm talking about understanding the concepts, there is a very little role, or I would say hardly any role for you to play. It is obviously dependent upon me, how I make you understand. You have to keep your mind's eyes wide open and try to just maintain your focus. Otherwise, the conceptual clarity undoubtedly will be delivered by me. When I talk about the learning part, if you maintain to revise, if you continue to revise as instructed and you don't leave the subject for the last minute or for just before exams, you will not face difficulty in learning. So once you read a chapter, supposedly we are reading a chapter for the first time, or the first chapter that we read, we will have a lot of interest. Maybe we will even learn 70%, 80% of our content. But once we go on to chapter number 2, 3, 10, 12, then we lose this grip on the subject. This is bound to happen with every student, so don't panic about it. But you have to maintain that continuity. Supposedly, you have a good grip over chapter number 1. You don't have to leave that chapter even when you have learned it. So, constant revision, my dear, is the key. First revision must be done after the class within 24 hours, undoubtedly. This might be the repetitive thought that the teachers are delivering to you, but trust me, this is the important key factor in your success. So, constant revisions are a must, and you must revise within 24 hours. The first revision has to be done. We will take efforts in making you learn, sometimes learning mnemonics and all that also, and you also have to constantly take efforts in learning. Presentation part, we have questions to practice. Now, how are you going to study? Ma'am, do we need to prepare short notes? That is the first question that students ask. Well, there is no need for you to prepare short notes. You will be provided the charts for revision. However, right from today, you must have a copy, you must have a registered diary, whatever you call, along with me. How is that going to help you when we are not supposed to prepare any short notes? Well, you will be noting things, but you will not prepare those fair, crisp notes as needed. Because I know that with the class, it's very difficult to prepare that beautiful notes which go on in the long run. And after the class, you will not invest so much time in just making notes. So when you are doing the class, you have a copy with you, and in that copy, what are you going to note? Supposedly, I am teaching you a section. You will note, you will note, you will just give a heading, that section number, and you will note all the points that I am telling you. Okay. If there is any example that I'm telling you, note that example. If I'm writing something and you find that relevant, write it. Don't try to understand the context and everything. Okay, because you're not making any fair notes. Then how does it help, ma'am? Point number 1, it helps you in writing practice. Point number 2, it helps you in getting yourself involved in the class because it is a theoretical subject, undoubtedly. Right. And point number 3, if at all in future when you're studying before exams and you get stuck in any concept, you can refer to this copy, open that example, review that example so that you will be able to relate. And 90% of your difficulties will be solved because then you are able to understand, okay, ma'am said this in this reference or in this context. So trust me, this has actually helped a lot of students. Okay. So how are we going to approach? You have to have a copy. You have a highlighter if you have that printed set of notes, right? Otherwise, you have to see how you can highlight or how you can just note that important things. Okay, so a copy is must, right? Now, we are reading corporate and economic laws. Economic laws, since we're not beginning right now, we'll discuss them later. But of course, corporate laws. There are two terms. One term is law or laws. The question is, what do you mean by law? What does the term law means? Law is set of rules and regulations. Why do you think we need law? Okay, imagine supposedly there's a cricket match going on, or maybe there is a football match going on, and there are no laws or no rules which are being made. Anyone is doing whatever they want to. Do you think you can play a match? Do you think you can play a game? No, you cannot. If in just a small game you need ample of set of rules and regulations, if this happens, this is going to happen. If this happens, this is going to happen. Then to run a whole country, undoubtedly law is needed. Law is needed to live a peaceful life in a civilized society. Needed to live a peaceful life in a civilized society. Okay. So you need laws, you need regulations. Why? Because there are different set of people that we have, different types of people, and they may all have different types of opinions. Someone wants to drive the car at a speed of 100, someone wants to restrict it to 20. What should be followed? If someone wants to drive at 100 and someone wants to restrict it at 20 and is not giving a pass or giving, what do you think should happen? So there are traffic rules to govern the same. Because there are different types of people and we cannot all reach to one consensus, we have reached to a consensus through law, right? Through law. Now, when after independence, the British era ended, people of India, basically the then leaders, thought that how now our nation should be governed. If we continue to leave everything like this and do not make any laws or do not give any power or anything, then the people, we will again not be able to live a peaceful life. So to live a peaceful life in a civilized society, we must have laws. So they made the most fundamental document ever, the supreme document ever, which is our Indian Constitution. Indian Constitution is supreme. Okay. So we have our Constitution, which is the supreme law. It tells us we live in Republic of India. That is, public has supreme power. The government will be elected. That means ultimately we have the supreme power, we have the power to make laws. We cannot make laws on our own, so we elect the representatives, right? So the supreme power will lie in the hands of general public and their elected representatives. That is what the Constitution tells us. Constitution gives us a lot of rights, that you have the right to equality, you have the right to freedom, you have the 6 fundamental rights which the Constitution confers. Apart from that, Constitution also tells us that public will have the supreme power, public along with its elected representatives. That means we cannot, and the law cannot be made going to that 130 crore people and asking everyone, do you agree to this? So for that we have representatives. How they are elected? How they are elected? We have 2 types of elections. We have a lot of other elections also, but I'm talking about where we do the voting, Lok Sabha and also the state legislative assembly, right? So when Lok Sabha, we elect some representatives. They can be from different parties, not necessarily the ruling party. Central government is formed by party having majority seats, but central government does not make law. Central government has not been conferred the power to make law. So we say that Modi ji has made this law. No. Central government does not have the power to make law. Yes, the power lies in the hands of these elected representatives. So we have the people who sit in the Lok Sabha. We elect someone from our territory, and that person goes and be a part of Lok Sabha. Right. Likewise, we also have Rajya Sabha. In Rajya Sabha, we also elect some we also have the elections for state legislative assemblies. Right. Now, these people elect the members of Rajya Sabha. Okay. Lok Sabha, Lok Sabha plus Rajya Sabha plus president is equal to parliament. And a parliament has been conferred power under constitution to make central act. What is central act? That also we don't know right now. Right. Okay. So ultimately, it's our elected representatives who make laws. Laws are some set of rules and regulations. Now, some set of rules and regulations, if they pertain to a particular topic, like we have certain rules with respect to company, right? So we have drafted all that rules, and that is known as a draft. That is known as a draft. The draft is being presented in front of the members of Lok Sabha, which we have elected. If they find that yes, this law should be passed and it should be made applicable, so they approve it. Then it goes to Rajya Sabha. They also approve it. Then it goes to President. President gives its assent and a bill becomes an act. A bill becomes an act. Right? So this is how the bill is converted into an act. I am telling you a lot of things, but of course in a very concise manner. This will not be asked to you in examination, so I'm not devoting a lot of time, of course, in this. And moreover, you are at such a level that you of course have surpassed all these basics. You must be knowing these basics, so I'm keeping it concise. Right. I'm not explaining you literally who are the members of parliament, who are MLAs, and if we are not discussing about the constitution or how the legal system works. Right. We just want to know the basics. Okay. So constitution has given the power in the hands of public. Constitution also has given the power, also gives the power to make laws on certain matters. Union list to parliament. Example, income tax. On certain matters, state list to the state legislature that has been formed. Right. So on certain state matters, the state legislature can make law. On certain central matters, parliament can make law. Right. So using this power as given under union list of constitution, parliament has made law or has made an act applicable centrally to the whole of India as Companies Act. As Companies Act. Okay. Law undoubtedly is needed. If we will start with company in the next class. Basically, I'm not even discussing why you need a company or anything like that. I'm just discussing the basics of law today with you, right? So, who has the power to make central acts? Act is a specific type of law. Law means act plus rules plus regulations plus ordinance plus circular plus notification. This all, everything. Law is a much wider term. Act means all the regulations summed up together relating to a particular thing. Maybe Insurance Act relating to insurance, Companies Act relating to companies, SEBI Act relating to SEBI, right? Indian Contract Act relating to contracts. So all the regulations relating to a particular thing are summed and come together. That's known as Act, right? Then we have rules, we have regulations, we have some circulars issued by government, we have some notifications which the government issues, right? So different powers have been conferred under different statutes. Clear? Right? So very basic thing, we all need law, right? We all need law, and that's why laws are mandatory. Laws have to be made. Who can make law? Whoever has the power to make law. So power has been conferred through constitution. Parliament also has the power to make law. State legislature also has the power to make law. And there are certain matters which are given in the concurrent list on both can make law. Okay, so we have three types of list, right? In which some matters have been prescribed that on these matters you can make law. You have the power to make law. Okay, how the law will be made, that also has been specified. As I told you about a central act, that you need this approval, a bill is made, and then you need these necessary approvals, and thereafter an act comes into picture, and an act is being made, right? So I hope this is clear. Now, when I'm talking about corporate law, it means I'm talking about corporates. Corporate means company and also includes other body corporates. When I talk about company, the most supreme law or the most important law or an act that we have is Companies Act 2013. Okay. We had many other previous acts also under company. Companies Act 2013 applies on company. Company is nothing but a form of business organization. So if you want to do a business in this particular form of business organization, you have to follow Companies Act 2013. Right? Okay. Now, from the next class, we will start with the company. Company is basically a group of people who are coming together and doing a business with a common objective. Okay. We have to discuss Companies Act. Companies Act, my dear, has 470 sections. They have been spread over 29 chapters and we have 7 schedules. Imagine 470 sections. Difficult to read, right? 470 sections. Do we have to read all the 470 sections? No, you don't have to read all 470 sections. You have to read a limited content. So whatever is there in our syllabus that we will read, of course, I cannot say from section number this to this because there are some selected sections from different chapters which you have to read and that we have designed accordingly. Right. We are going to start our syllabus undoubtedly with Companies Act 2013. The first chapter in our syllabus is Companies Formation and Conversion, in which broadly you have these four topics. What are the four topics? Some basics related to company, how the companies are being incorporated, some doctrines, and also the process of conversion. Also, how the LLP can be converted. That is given in section 366 of Companies Act, and we have companies authorized to register rules 2014. Here also we have a lot of rules that we have to see. And something related to foreign companies. For that, we have a separate chapter, companies incorporated outside India. Okay. So we will start with this, then we'll discuss this, then we will discuss this, and this we will do at a very later stage of our syllabus, not right now. So although in our study material, this is also included in this chapter only, we are not going to discuss it right now because it is too early for you to understand those heavy concepts. Unless you have read about investigation, you cannot read about foreign companies investigation. Right. So you will be at a too early stage to understand those concepts. We definitely cannot do that right away. Okay. So this I have written over here as well, that we are going to discuss it later. We will start with this, that what do you mean by the company? What are the basics, the administration, the applicability and extent, and then you have the characteristics. So till here, we are going to discuss today, and the characteristics of company we'll discuss in the next class. Okay. Now, when I say company, what is company? Company has been defined in section 2, clause 20. When I say Companies Act is divided into 29 chapters. Chapter 1 is preliminary, which contains section 1 and section number 2. Section 1 has short title, extent, commencement, and applicability. Section number 2 only has certain definitions. Okay. Company is also defined in section 2, clause 20. Short title, we will call this act as Companies Act 2013. Extent, it applies to whole of India. When did it start? The first section was notified on 30th August 2013. And where is this applicable? What do you mean by applicability, ma'am? Supposedly, you have beautiful neighbors, but their kids absolutely spoiled. You don't like them at all. Can you control them? Outside your territory. We cannot control our own siblings or kids, right? How can we control someone else? It is outside our territory. Our laws, our thinking, our vision does not apply to them. Likewise, if government has made certain laws, where is it going to be applicable? On which, if I am doing a partnership business, do you think this Companies Act will apply to me? Definitely not. This Companies Act will apply to me if I am a company. What is a company? The question is, what is a company? The company means companies registered under this act. Companies registered under this act. Okay, fine, ma'am. We can say that the Companies Act is approximately 10 years old. Companies Act 2013 is approximately 10 years old. Let's keep it round figure. right? And we also have something called as Reliance Industries Limited, which is approximately 50 years old. That means it is not registered under Companies Act 2013. That means it is not a company. What are you saying? It is a company, undoubtedly. It is a company. That means companies registered under this act plus registered under previous company law. What are previous company law? 1913, 1866, 1956. Companies Act 1956, it had a very long tenure, right? There were many companies registered. Only the name has changed with some amendments. In fact, after 1956, almost the whole act got repealed, right? The act has been repealed, a new act has been introduced, right? But there are some provisions intact also. Of course, the renaming has happened. That means company, even if you were registered under some previous company law which was in existence at that particular point of time, you are still a company under Companies Act. So this Companies Act 2013 will be applicable on all the companies. That means the companies which are registered under this act plus the companies which are registered under previous company law. It will also be applicable to special three types of companies, that is banking, insurance, and electricity. Banking, insurance, and electricity. But sometimes there comes a problem. We have a banking company like Axis Bank Limited. It's a bank also and it's a company also. A company which is being conferred the license to do banking business, right? It is allowed to do banking business, so it is doing banking business. But since it is a bank, it is also being regulated by Banking Regulation Act. It is also being regulated by RBI. Now, if Banking Regulation Act tells us that you prepare your balance sheet in this format, and Companies Act tells you prepare in this format, which format will I follow? If I am a banking company, there will be a fix, there will be a problem, there will be a conflict, a dispute. Which one to follow? So, in such situations, for these three special types of companies, it is written they will follow Companies Act only till their specific provisions are not inconsistent. That means if Banking Regulation Act tells you something, you will follow that. You will not follow what Companies Act tells you. If Electricity Act tells you something, you will follow that. If Insurance Act tells you something, you will follow that. If ADA Act tells you something, you will follow that. ADA is also about insurance only. Insurance Regulatory Development Authority. We have to read something about insurance sector also. Okay, so you'll follow that. You'll follow that specific provision, that specific regulation. I hope that's clear. Right, ma'am. The Act has this administration, I'll discuss a little later. It extends to whole of India, applies to companies incorporated this law, previous, insurance, banking, electricity. So far, the provisions are consistent. If they're inconsistent, it will not apply. Any other company which is governed by special act or any body corporation which government may notify. Very simple thing. And this probably already knows, I'm not dealing in a lot more detailed manner. Okay, I could have gone in lot more detailed manner. For 2 hours. I can take a class only on the introduction and even more. But I'm restricting myself because you have a lot of more core content to discuss, right? So we'll not waste a lot of time on this basics, right? Because you already know this and they are not very much needed in examination. Now, we have something called as administration also before we actually begin with Companies Act, although we have the basics of company also to discuss. But before we begin that, something called as administration. Or basically, I would say something called as authorities under Companies Act. We have MCA. This is an online portal Also, although this is Ministry of Corporate Affairs. Now when I say Parliament makes central act, we have the government being doing three types of functions. One is executive, second legislative, and third judicial. So we say the legislative powers are with Parliament, but supposedly Parliament has made Companies Act, and this Companies Act tells you to furnish information. The question is how this will be executed, how you have to furnish information. That will be being told by the government, central government. Central government operates through different ministries, right? We all know that. Likewise, we have Ministry of Corporate Affairs. So deal with corporate affairs, we have MCA. Now, MCA is going to make rules. How can you furnish information? So MCA supervises everything because it is undertaking the executive function of government. It executes, it ensures that proper execution of the laws are being done. So it also has the power to make rules, how you do that. Not what you do, but how you do that. Okay. And then we have undoubtedly judicial, our judicial system. Right. So we have MCA, which governs everything, which is the executory body of ensuring that everything is in order. And we have an online portal also in the name of mca.gov.in where we do the filings. We have ROC, Registrar of Companies. It maintains records of all companies, and this is appointed in every state. Then we have something called as RD. RD, my dear, is regional director, who is in charge of a region, who supervises working of all the ROCs. Then we have NCLT and NCLAT. They both are judicial body, which acts as courts under Companies Act 2013. Right now, this much piece of information is undoubtedly sufficient for you. Okay, so we have something called as ROC, which undoubtedly we'll read many times. Registrar of Companies, which maintains the records of all the companies and is appointed in almost every state. Some states have two ROCs also. Only there are 2 states which have 2 ROC. Then we have a regional director who is in a region and supervises the ROCs of all the region. And then we have NCLT, National Company Law Tribunal, and National Company Law Appellate Tribunal, which acts as a court only for dealing with the corporate issues. Okay. So I think so far the things are clear. Administration part is also clear. Okay. So I wind up the class here itself. Today was just an introductory session. I hope now you are thorough with your subject. You know what you have to study. And out of that corporate and economic laws, we have started with corporate laws. We have 3 topics in corporate laws: Companies Act, IBC, and corporate governance. We have started with Companies Act. Companies Act is divided into 29 chapters. You don't have to read all the chapters. Whatever is there in your content, that has been divided into different chapters: companies formation and conversion, investments and loans, and so on. So one by one, we are going to read all the chapter that we have to. Undoubtedly, you don't have a lot of coverage, so you don't need to worry. In Companies Act, in fact, the coverage has been reduced from the old syllabus, I would say. So that's a reason to be happy. But still, the content still is not so less, it is still huge, and we have to put in a lot of effort. So I hope you're all charged up and dedicated completely, and you are going to develop some very good habits because you have to ace a subject like law, right? Okay, all the very best. See you in the next class. Thank you.
Hello everyone. Welcome to the next class of our current batch, and this class is also about basics. We are going to discuss about the characteristics of company in this particular class. If you actually go out and ask a child who is studying in class 5th that can you tell me ABCD, or let's read ABCD, all the alphabets, all the letters and all that, he will be like, are you kidding me? I read that so long before, and it's on my tips. And so are these characteristics of companies for you. You have been studying this, I think, from class 11th for sure, when there was a subject called as business studies, in which you read about the different forms of business organization, and one such form of business organization is company. And when you read about company, you of course read about the features of company or characteristics of company. So this is not something very new to you, but still we are going to discuss every point of it, since it is there in our syllabus, and more importantly, since I want you to be very clear with the basics. Okay, so let's start our today's class. But before we actually go out to see, okay, artificial person, perpetual succession, my question to you is, why company? Why do you think this beautiful form of business organization has at all been introduced? So for that, let's watch a video, an animated one designed by me, which is actually going to give you some fun clarity. And let's have a look.
सारी उम्र खेलता रहेगा या कोई काम भी करेगा?
बहुत हुआ अपमान, आप
So he
करूंगा
is
मैं
Mr.
काम।
Bunny and he's being insulted, and after his insult he starts a proprietorship business with 1 lakh rupees. Okay. He takes a loan of 5 lakhs. But with 1 lakh investment, he had to pay 5 lakhs to bank because he started a proprietorship business. Oops. So with Bunny's death, the business also dies because it was proprietorship. So Bunny got to option number 2, and he started a partnership business with Honey. But loan again, loss again, and liability
अब आप ही
again.
कोई रास्ता दिखाइए
So
सीए
he wants
साहब।
to seek
सारी
the
उम्र-
help of professionals like us. He walks up to CA, CMA, CS, whoever he might go, they all are going to advise him one thing only, and that's it. That why are you engaged in these traditional forms of business organization when you can gift yourself the corporate status? How can you do that? By forming a company. A company has a lot of benefits, a lot of features, and a lot of exemptions and all that we are going to read at a later stage. But at this particular point of time, had you formed a company, your business would not have died because of the feature of perpetual succession. Had you formed a company, you would not have to pay 5 lakhs to the bank. If company has taken a loan, if your business has taken a loan of 5 lakh, the business only has to repay if it can. If it cannot, why will I repay? Right? So there are some advantages, some features of a company which we are going to read in today's class, and let's get going with the very first one. And one more thing, you have to remember this character of Bunny because we are going to use it a lot of times. So he is one of my favorite characters. So our advice to Bunny is that go for a company. Which type of company? Private, public, OPC, etc., etc., that we are going to discuss later on. But first of all, company. Company. The first feature of company is artificial person. What is artificial person? Of course, the company is a person. Can it get married? Imagine marriage of, supposedly one fine day you wake up and you receive an invitation card which says that Reliance weds Infosys. How about that? Can two companies get married? No, of course they cannot. And when they cannot get married, they cannot even go for divorce, right? Because they are artificial persons, they do not have the ability to see, they do not have the ability to speak or hear, nor they can get married, nor they can go for divorce, etc., etc. Then why are they person? Because they have a separate existence, because they can legally do a lot of things which an individual can. Just like we are citizens of India, they're also corporate citizens of India. Okay, so a company is an artificial person. It is not something which is created or which comes into existence by natural birth. It comes into existence by some artificial process, that is by some legal birth, right? So that legal process is known as incorporating a company. How a company is incorporated, that we will study later, right? But company comes into existence by operation of law. So under law, some procedure will take place, and that will help us to bring a company into existence. Then comes separate legal entity. With separate legal entity, we come to a very famous case law, which is Salomon versus Salomon. I think throughout your journey and throughout your journey of company law, I would say, one case law which you must remember and which I think everyone should be remembering is Salomon, right? If there is just one case law that you can remember, it has to be Salomon, right? So it's a very famous case law. It's like in Bollywood movies, you might remember some movies like Dawn or like DDLJ, more importantly, right? So it is that case law for company law. What is Salomon versus Salomon and Company Limited? Well, Salomon was a very intelligent person. What he did is, he formed a company. Fine, ma'am. Salomon formed a company. Okay. Just a second. He's Mr. Salomon, and this can be Salomon's wife, who cares? Salomon had a proprietorship business. Is it okay? Right. Salomon had a proprietorship business. Now, he decided that I'll form a company, and he wanted to form a public company. For those who do not know, a public company requires at least 7 members. Okay, fine. So he needed 7 members to form a company. One was he himself, second was his wife, thirdly his 4 sons and 1 daughter. So that comes out, the total comes out to be 7 members. So the prerequisite of forming a public company was satisfied that he got 7 members and he incorporated a public company. Can he do so? Of course. Why can't he do so? Supposedly, I'm running my proprietorship business, as in Book My Video. I want to tomorrow incorporate or convert this into a company. Can I? Yes, of course. Subject to name availability. I can incorporate a company and transfer the whole business in the name of the company. That's very well possible. So Salomon did the same. Now, there's no problem in that. The problem arises. Salomon, when transferred his business to the company paid him certain purchase consideration. You have you very well know about that amalgamation and all that, right? So you know that whenever a business is acquired, we have to pay certain purchase consideration. So in the form of purchase consideration, he was given some shares and he was also given some debentures. Right? He was given some shares and he was given some debentures. So if we talk about the balance sheet of Salomon Company Limited, there were certain assets, and on the liability side there was share capital. Who were the shareholders? Salomon, his wife, his 4 sons and his daughter, right? Apart from that, there were certain debentures which were in the name of Salomon himself, and then there were some other unsecured creditors and all. Okay. Still no problem. So far, no problem. All good. Now, the problem arises. What is the problem? The problem is that the company ran into financial difficulties. The company was not able to survive anymore. And now when the company was not able to survive anymore, the company had to sell off its assets and pay off its liabilities. When we undergo this process of winding up, what happens is that when the assets are sold, first of all, the secured creditors are paid off. Then unsecured creditors are paid off, and then shareholders are paid off if any money is left for them. Clear? So, who are the secured creditors? The debenture holders. Who is the debenture holder? Salomon himself. It is Salomon's company. He himself is the debenture holder. So, when the assets were sold, he took away a lot of money because he was the debenture holder, and there was less left for the unsecured creditors. So they got very angry. They said that it is Salomon's company only. He should not get the money first. We should get the money first. But ideally, if we talk about under the provisions of law, the debenture holders have to be paid first. It doesn't matter whether it's Salomon's company or someone else's company. The company is separate and Salomon is separate. Salomon in the capacity of debenture holder, in the capacity of shareholder, in the capacity of director, whatever he be, he is different. Company is different. They both are separate. You cannot say that Salomon is the one who is, Salomon and company are the same thing, so company should not pay to his own, etc., etc. No. This was the judgment of the court, and this clearly establishes the principle of separate legal entity. So one of the beautiful feature of company which was established by this particular case law, Salomon versus Salomon Company Limited, right? Now, some of you might find this unfair. Imagine Mr. Ambani ji, okay, somehow Ambani's company has to now wind up. It's just an example, okay, so don't be too emotional about it. I take my own examples a lot. Throughout the classes, you might see Shivangi ma'am dies, you will see it a lot of time, okay, that I have started a company, then I died, so don't get emotional about anything. These are just fictitious examples. So supposedly, Mr. Ambani's company has to wind up. Now, what he did is, he took away all the money and no money was left for the creditors. Wouldn't creditors get angry? That it's Ambani's company only, he took away all the money. So he is safe and sound and he destroyed all of us. We are now running into financial difficulties because we could not recover our money from Reliance. So don't you think that's unfair? Because they are the ones who are managing the company. They can twist and turn the company the way they want to. So don't you think it's unfair? Yes, it is. Well, because this is unfair, we have a concept called as corporate will. which we will study a little later. Okay. So let's have a look at our case law. Salomon had a prosperous business. He formed a company. These were the shareholders, and he got this purchase consideration. The company went into liquidation. The assets were not sufficient to discharge everyone, so nothing was left for the unsecured creditors, and they were angry thereafter. They pleaded that Salomon should not be paid anything and we should be paid, but the judgment was that company has its own existence, which is separate from its members, and a shareholder cannot be held liable for the acts of the company. Whatever happened, it happened with the company. Although the person was running the company, doesn't really matter. The company is different and the person is different. Clear? Okay. Now, we come to the next feature. Limited liability. One of the most beautiful feature of company, limited liability. See, if Bunny took a loan of 5 lakh rupees and he just had 1 lakh to repay, the bank will come to his house, attach his properties, attach his bank balance, whatever he has personally, not in the business, personally also, they will take away everything. But if you open a company, Salomon opened a company. If company is into financial difficulties, the company cannot ask for money from Salomon that you have a beautiful bungalow or beautiful farmhouse of 20 crores, you give me that. The company cannot ask like that. The company just cannot ask like that, right? The company doesn't have right to do so. Why? Because any member is not liable towards the company. The member is liable towards the company only up to a certain amount. Which amount, ma'am? Supposedly, this is a company, Salomon and Company Limited, and Salomon has agreed that, okay, I am going to take 10 shares of this company. So, I will give you 10,000 and I'll take 10 shares. Salomon has paid only 5,000. So, Salomon is liable to contribute to the company 5,000. Company can only ask for 5,000 rupees from Salomon. If someone has agreed to take 10 shares and has given full 10,000, the person is not liable to contribute any further rupee. So, zero liability, 5,000 liability. So, the liability of the members of the company is limited to the amount that they have not paid on the shares they hold. Clear? We will discuss about limited liability when we discuss about the different types of companies. So, when we discuss the different types of companies, we also will discuss about this. Okay, that is what is a limited company, what is an unlimited company. So, we also have an unlimited company. So, in all these cases, the members have limited liability. Company still has unlimited liability. The members have limited liability. It will either be limited to the amount of unpaid, unpaid on shares, or to the amount that they have guaranteed. Clear? Okay. Moving further. Perpetual succession. No matter who comes and goes, as I told you, Shivangi ma'am dies. Members, let's say for example, Mr. Dhirubhai Ambani, he incorporated a company. Why do you think he incorporated a company? Ma'am, to do some business, of course, but do you think he would have ever imagined that as and when I die, the company should also die? See, even in the worst of dreams, no Indian parent can think so, that whatever I am earning is for my own self. I don't think any Indian parent can do so. We always have this, we have the desire to earn not for our own selves, but for the younger generation, right? So we pass on everything to the generation. We pass on the legacy, we pass on the investments, everything. So likewise, we also want to pass on the business. It's not just about the legal here. It's also about the brand that you establish, about the values that you have put into the business. So Mr. Dhirubhai Ambani started with a vision. He started a company and he did not want that company to end. If you choose a business form of organization like a company, you get this beautiful feature that no matter whether I am there or not, there are members, there are directors, there is a whole procedure, there is law which has to be followed, and by following this law, by complying with this law, a company will never run into a situation of liquidation. So the company will always go on and on and on. Company is an artificial person. A person is born by natural death, but the company is born by the legal process of incorporation. So as and when the company is incorporated, how is it going to be wound up, right? How is it going to liquidate? That is also important. So we have a whole process of dissolution, and that's a legal process. So just like a company is created by a legal process, a company also gets dissolved by a legal process. That's the only way you can wind up a company. Otherwise, the company goes on and on and on for a foreseeable future. Till the time you can imagine 100 years, 200 years, 300 years, 500 years, whatever vision you have, the company is going to go on and on and on. We have an expiry date. Our life expectancy is 75, 70. It's quite reducing. Earlier, the people used to live up to 100 years. Now it's reducing. So we have a deadline, but the company doesn't have any. Common seal. What do you mean by common seal? Common seal, my dear, is the official signature of a company. Official signature, just like a stamp. Earlier it was mandatory, now it's not mandatory. That means a company may have an official signature, it may not have an official signature. Now, if a company doesn't have an official signature and the company wants to enter into some contract, who will sign it? If it has an official signature, we put a stamp and it's like, okay, the company has signed it. But otherwise, who will sign it? So we are going to read about the signing part and all that. I'm going to tell you who signs and everything. The directors are being authorized to sign that. So it is, what you have to remember is, it is the official signature, but it is optional. Okay, it is optional. Next is transferability of shares. Transferability of shares. Okay. What is transferability of shares? Supposedly, let's take the example of Salomon again. Salomon and Company Limited. Salomon had 4 sons. Often it happens that one of the son is not very worthy. He turns out to be someone who you cannot trust, someone who is duffer, someone who doesn't listen to you, someone who is not very good at academics and all the bad things, right? So Salomon doesn't want to give him any share in his company, but he has already given him 1 share. So Salomon thought, I'll take that share from my son and give it to my elder son. He's very disciplined, he's very sensible, he always listens to me and like things. So can it be done? Yes, the shares may be transferred. Some students have this misconfusion or misconception that shares cannot be transferred in a private company. Well, they can be transferred even in a private company, although there is some restriction about which we will study later. When we discuss about private company, public company, one-person company, then we will discuss that. Okay. But yes, they can be transferred. Okay, fine. So the shares can be transferred, great. Then comes your separate property. Again, let me take an example. Separate property. Actually, I took this example in my Hindi batch also. But I don't think I have to erase the whole thing. Okay, let's say for example, I started with a company. I started with a company and I have a godown. In that godown, I started with a company. The company has a godown. Godown has certain mobile phones. Okay. Because I'm doing that business of mobile phones, I'm going to buy the mobile phones and sell them. Right? I buy them at a wholesale price and I sell them at retail prices. Now, since one godown is filled with thousands of mobile phones, they're very prone to risk. There might be some short circuit or anything like that, and the whole godown may run into fire. So for that, I want to take an insurance policy. I want to protect my mobile phone. So I called the insurance company and took a policy in the name of Shivangi Agarwal. You must have got my mistake by now. I took the insurance policy in the name of Shivangi Agarwal. The funny part about insurance companies is that whenever you want to take any policy, they are so desperate to sell the policy that they will agree to any and everything that you say. Okay, this will be done. There will be no problem. I am here. Right. So, such over promised statements led me to this, and I took a policy in the name of Shivangi Agarwal because I thought it's my company, it's my godown, these are my mobile phones. Now what happened is, somehow God did not favor me and the godown actually was caught by fire and the mobile phones were destroyed. But I was sitting calmly and satisfied that no problem, I have an insurance policy and nothing is going to happen to my mobile phones. So I was kind of relieved. But then came the insurance company, and at the time of claim, they are like, let me see. No, this claim is not possible. So they are always like that, insurance companies, and they came and rejected my claim straight away. I said, why? Why this is happening to me? They said, because the mobile phones belong to the company. I said, yes, of course, but the policy belongs to you. You don't have any interest in these mobile phones. I said, I do have an interest. No, you are different, the company is different. We cannot pass a claim on such goods which do not belong to you. These goods belong to the company. This godown belongs to the company. I said, you should have taken care of this at the time of taking the policy. No, at the time of selling the policy, you were very eager and you did not take care of all these things. They said, we don't care about that. Ultimately, what I am trying to conclude from this particular scenario is that the company has a separate property and we can in no way claim that property to be ours, despite the fact that I have incorporated the company, I am the shareholder of the company, I run the company in the capacity as a director. I cannot claim it. Right? So no member can claim to be the owner of company's property. I hold the shares of Reliance, that doesn't mean I own the property of Reliance. Right? And even a member does not even have an insurable interest in the property of the company. This is exactly what I told you through that example, right? Okay. Capacity to sue and be sued. So a company is a body corporate. You can sue it, and the company can also sue someone else if the company suffers from any breach or anything like that. Okay, simple point. Now we come to an interesting concept of corporate veil. As I told you, many a times we feel that this concept of separate legal entity, that they are different, can be misused a lot of times. I have to do any fraud. Let's open a company, let's take some money and all, we will run away, and the company will now see. Because they cannot come, the bank person or the financial institutions or anyone that I have defrauded, they cannot come and claim money from me legally, right? Because it belongs to the company. I've taken money in the name of company, so they cannot come and claim anything from me. So I can easily get away with it, right? But this is something which should not be allowed. So government has taken a step at different places. What government has said is that first of all, you need to understand this concept. There is a wheel of incorporation. Have you heard of that song, Parde mein rehne do, parda na uthao? I hope you understand what parda means. Parda means curtain. Anything which is behind the curtain, we cannot see it. Imagine a puppet show. This is not the file. Imagine a puppet show. What can you see if a puppet show is going on? What can you see? Oh, see this pink puppet. This is looking so beautiful. Oh, see this green puppet. It's slightly down. Oh, look at this yellow puppet. It's turning towards the left. We can only see what these puppets are doing. We cannot see who are the person who are behind this puppet. Maybe this person is intentionally doing something to the puppets, right? Do you get my point? So exactly this is what happens in the case of company also. We have company which is being run by the directors, by the members. There are two decision-making bodies of a company. One is the board of directors and one is the shareholders. Board of directors look after the day-to-day affairs and everything, and some powers are reserved for the shareholders also. They are the two decision-making bodies of the company. So they take decisions, but whatever decisions they are taking, however they are turning the company, it's the company which is visible because they are behind that curtain. And they are shielded, they are protected from that curtain. They are shielded, they are protected from that curtain because they do not have to answer anyone. They are not answerable to absolutely anyone. It's the company. If you remember, the same example can be used for this case also. I'm not going to use the surnames. The ones who are smart will obviously understand. If Mr. Manmohan is doing something, he comes up with a policy, we blame him. He has done this, he has done that, but he is someone who might be guided by Sonia. The way she is turning Manmohan, he is turning in the same way. Right? So can you go ahead and file a case against Sonia? No, because Sonia is different and Manmohan is different. Although we have a clear indication that this is happening, we cannot go and file a case against her. But in the case of company, we cannot let this injustice happen or prevail. So when we know that the company is doing some fraud, but it's not actually the company, because company is an artificial person, it's these people who are doing them. So government should take some steps to expose them and penalize these people who in the name of company are doing something which they should not. So this is, my dear, known as lifting or piercing of corporate veil, because there was a curtain which protected the members from the actions of company. If company does anything wrong, company is liable, company is responsible, company should be penalized. This is the general rule, general wheel of incorporation. But at times the law disregards this and says that lift the curtain. And when you lift the curtain, you will be able to see the real persons who are behind this action of company, and accordingly they will be penalized. Okay, so a company is in law. A company is in law distinct from its members. This is known as wheel of incorporation, but and that is, they are shielded from liability which is connected to company's actions. But when the law disregards this corporate entity and actually looks behind the individual members who are running the company, that is known as lifting of corporate wheel. Under lifting of corporate wheel, we see two classifications. One is statutory provisions, and the other is judicial interpretations. Judicial interpretations. We are going to discuss here the judicial interpretations. What is, ma'am, statutory provisions? Statutory provisions, that the provisions which are made under statute. Under Companies Act 2013, you must have seen, if you remember, there was a provision of misstatement of prospectus, wherein if in the prospectus there is some error, okay, it is not the company which is liable, it's the people who prepared the prospectus, they are liable. So this is a provision which is there in the statute itself, which disregards separate legal entity and instead pays importance to who is the person who is behind this prospectus and penalizes that person. So there are many provisions which are there in the statute which ignores this concept of separate legal entity and lifts up the corporate wheel, which we will read as and when we progress Companies Act. Okay, but there are also judicial interpretations. What are judicial interpretations? Let's say again, let's take that example of Mr. Ambani. Supposedly this happens in a real life, that Mr. Ambani has actually done that fraud and he took away all the money and all the creditors are shattered. All the creditors, what they will do? They'll come to us. We cannot do anything about it. So they'll go to court. When they go to the court will admit their application and start proceedings. So during proceedings, the court has two choices. To say, no, nothing can happen. The company is different, Mr. Ambani is different. Whatever he has done is okay. So that is maintaining that principle of separate legal entity. And the other one is disregarding corporate personality. That is looking behind the real person who has done this, and whoever has done this should bear the consequences. Right? So there can be two situations where courts decide whether to lift the corporate wheel or not. We have some famous case laws through which we have established that, okay, if this happens, if someone is trying to evade tax, then we will lift the corporate wheel, right? So there are certain cases where we have got judicial interpretations, where we have got judicial cases where the courts have taken this judgment of lifting the corporate wheel, which we are now going to study. You don't have to learn the names of case laws. Ma'am, which case laws we have to learn? See, it's not very easy to learn all the case laws. So I'll tell you which case laws you have to learn. Hardly 5 case laws throughout the course I'll tell you to learn. So don't worry about it. And more importantly, you must remember that under what circumstances is corporate veil lifted. Although this is a very basic provision and a basic question which should not be asked in examination at your final level, of course, that is what I sincerely believe, but still maybe 1 mark, 2 mark, 3 mark they may ask, since it is a part of your syllabus, right? Okay. So the first point, protection of revenue. What is it? To protect the revenue means revenue of government. What is the revenue of government? Taxes. Government gets revenue from collecting taxes. State government from state taxes, central government from central taxes, right? So to protect this tax, government may lift the corporate veil. What happened in this case? Dinshaw, Menegji, Pettit. Dinshaw, Menegji, Pettit had huge income. Imagine you get 50 crores a year. Let's imagine. Oh wow, ma'am, such a peaceful life it would be. Still, your first concern as a professional would be, oh my god, such heavy taxes I have to pay. Is there anything I can do about the taxes? Supposedly you get a salary of 50 crores. Then you have no other way than to pay taxes, right? So such heavy taxes you had to pay. But Dinshaw, Menegji, Pettit, he had income from investments. So he had huge investments, and from that investments he was earning. Whatever he was earning, he had to pay heavy taxes. So he decided one fine day that let me incorporate 4 companies and let me transfer my investments. Let me split my investments and transfer them to these 4 companies. Now what will happen is, I will not have any income. And since my money has gone to these and they are going to receive the income, I will take my money in the form of loan, and on loan I do not have to pay any taxes, and their incomes will also be reduced accordingly. The tax and all, tax planning and all, he did that. So it will be reduced. So just for reducing this tax burden, just for evading tax, these companies were formed. They were not doing any business. They were kind of shell companies. Okay, they were not doing any business, nothing at all. They were formed only for the purpose of evading tax. And since they were formed only for the purpose of evading tax, the judge said, although these companies are different from Mr. Dinshaw. Mr. Dinshaw is a separate entity and these companies are a separate entity. So the income of this particular company should be treated as income of this particular company only. But since these companies are formed for evading taxes, we will disregard this corporate personality and consider this income as of Mr. Dinshaw only. So in this case, the judge actually went out to lift the corporate veil. Clear? Next case, next situation, determining enemy character of the company. Daimler Company Limited versus Continental Tire and Rubber Company Limited. Daimler. Okay, so here we have, the company was incorporated in England. Okay, the company was incorporated in England, but all the members, all the shareholders were the residents of Germany. Residents of Germany. Now, do you know what happens? Do you know what happens? During war, you must have read this in Indian Contract Act. What happens during war is the entities of two countries. The countries who are at war, they are not at peace with each other. The two countries who are at war, the entities of those two countries cannot also contract with each other. They cannot, right? Because they have turned out to be alien enemies, right? So they cannot contract with each other. Now, this particular company entered into a contract with another company of England. Prima facie, there looked no problem. One company of England is contracting with another company of England only. Why the problem? Because Germany and England are at war. Why this problem? But if you look deep, you will realize that this company is only looking like an England company. It is actually a German company because all the shareholders are of Germany. So to determine whether they are alien friends or enemies, we have to disregard this corporate wheel and look behind the real person. And when we look at the real persons behind this, we come to know that yes, they are alien enemies. So when we want to determine the enemy character of the company, we can lift the corporate wheel just as judge did in this particular case. Right? Okay, next. Smith, Stone and Light Limited versus Lord Mayor etc. of Birmingham. In this particular case, if you understand it in an easy manner, supposedly I call you and I tell you that go to the DM of your city and give this particular proposal. If he agrees, collect advance from him. You go, you went there, you gave him a proposal and he agrees, and then you take some advance. That advance belongs to you or me. That advance belongs to me. Why? Because you were merely acting as an agent. In the same manner, the company formed another company, turned a partnership firm into a company as its subsidiary, and that subsidiary was not doing any thing separately. It was just acting as the agent of the company. So when it is just acting as the agent of the company, then whatever belongs to that company belongs to the parent company. So when some compensation was decided to be given to the subsidiary company, that compensation should belong to the parent company. You don't need to get into very deep details of this particular case law. All you need to remember is this. Okay. So when some companies form another companies as subsidiaries to act as their agent, the corporate wheel is lifted. Next. Lifting of corporate wheel could be done in case of transfer of shares of company which actual sale of land which the original allottee was prohibited to do so. Okay, let's say there are these 4 persons who have formed a company. Okay, this company supposedly has got some land which is allotted by some government, and this land can't be transferred for 10 years. This land belongs to the company. The land cannot be transferred for 10 years. That is the only condition of allotment. The shareholders transferred their shares to another company. Now, ideally, the land belongs to this particular company. Although transfer of land was not permitted, but now the company is different and the shareholders are different. So shareholders can transfer their shares as and when they want to, because there is transferability of shares, right? So company did not do anything. So company should not be penalized, and they can also not be penalized. Do you get it? How smart, right? So in such a situation also, a corporate wheel was lifted. and it was said that no, you both are the same and you have transferred this company, you have transferred this land indirectly, and hence the allotment is cancelled. Okay. Next is the case of fraud, Jones versus Lipman. If you form any company for just defrauding someone, the corporate veil will be lifted. And lastly, we have, if the company is trying to avoid legal obligation or welfare legislation, we have this rubber industries. Okay. Now, a company had some income, and based on the profit of the company, bonus is computed. You all know about industrial laws, you know about Payment of Bonus Act. So bonus has to be computed according to the relevant laws which are applicable, and bonus has to be paid mandatorily. It has to be paid to the workman, to the labor, right? Under labor laws, you have read about it. So the workmen were very happy because of the income of the company. They were getting huge bonus, but the company was not so happy. The company thought that I should reduce my profit just to not pay the bonus. So what company did it? All the investments from which it was receiving that interest income, dividend income, etc., etc., it opened another company and transferred all its investments to that particular company. Now what happened is the profit of this company reduced, and hence no bonus. Bonus is your statutory obligation, and just to reduce that statutory obligation or to get away with that statutory obligation, the company actually formed another company and transferred the investments. So this company and this company will not be treated as separate legal entity, and the court, Supreme Court, upheld and actually wanted to look at the real transaction by lifting the corporate veil. Okay, so this is what happened in the case of workmen of Associated Rubber Industries Limited versus Associated Rubber Industry Limited. The workmen of that company and that company, right? So that's it with today's class. Hope you have been able to recall the basics with me. What we have studied so far is the characteristics of company, artificial person, perpetual succession, limited liability, capacity to sue and be sued in its own name, separate legal entity, transferability of shares, separate property, right? All of that. And then we have discussed about corporate veil. Corporate veil is that veil of incorporation, that there exists a veil between the members and the company. The members are being protected, shielded or guarded from the actions of the company, and at many point of time this corporate veil may be lifted in courts by the judges or by using some past judicial interpretations or under the statutory provisions, right? So thank you children, and have a great day. See you in the next class.